There was a letter on my desk the morning I was assigned this case, not from the defendant. From a woman named Paulette Okafor, who described herself in the first line as the grandmother of the boy your courtroom is going to try to help. She had driven 4 hours from Beaumont, Texas, to drop that letter with my clerk by hand. She did not ask to testify. She did not ask to speak. She asked only that someone read what she had written before the proceedings began. I read it that evening. There was one sentence in it I could not put down. She wrote, "He has never once in his whole life stopped to ask whether someone needed help before giving it. That is the part of him the papers did not mention." I kept that letter. I am going to tell you about the case that letter came to be part of. Subscribe before I keep going, not because what I am about to tell you is dramatic, because it is the opposite of dramatic, and those are the stories that need the most people to hear them. Subscribe and turn on notifications, then let me continue. What I knew before the courtroom is this. In the early afternoon of July 14, 2023, the United States Coast Guard dispatched a rescue vessel to a reported capsized paddleboarder approximately 1.2 miles off the coast of South Padre Island, Texas. The rescue vessel was a 29-foot response boat Small 2, traveling at approximately 30 knots toward the coordinates of a man named Darnell Furlow, age 34, who had been in the water for 11 minutes. Between that boat and Darnell Furlow, anchored broadside across the channel at a heading that made passage impossible without collision, sat a rented 42-foot motor yacht. On the deck of that yacht, filming with a stabilized handheld camera and directing two assistants by earpiece, stood Marcus Renfield Okafor, age 27. He was 3 weeks into a 90-day brand partnership with a premium outdoor gear company. The shot he was setting up was intended for a platform reel. He saw the Coast Guard vessel. He did not move. That is what I knew. That is what the file said. What the file did not say, what no file can say, is what I saw when Marcus Okafor walked into my courtroom on the morning of February 6, 2024. He walked in fast, not nervously, the way a person walks when they have somewhere they believe they need to be. He was wearing a gray button-down shirt that was too big for him at the collar, the kind of shirt someone buys for an occasion they have not had many of before. He sat down at the defense table and he did not look around the room the way most defendants do. He looked at his hands, then he looked up at the bench, not at me, at the seal on the wall above my chair, and he held that look for a long moment. I did not know what he was reading into it. I watched him do it and I filed it away. There is always one thing a person does in the first 60 seconds that tells you something you will not find in any document. For Marcus Okafor, it was that. He looked at the seal of the court like he was trying to understand what this place expected of him. That told me he was taking it seriously. That matters more than it sounds. The victim in this case was Darnell Furlow. He was in the water for 14 minutes total before the Coast Guard vessel was able to navigate around the blocked channel to reach him via a secondary approach that added approximately 4 minutes to their response time. Darnell Furlow survived. He was treated for moderate hypothermia and lacerations to his left forearm, sustained when his paddleboard overturned in a wave wake generated in part by a vessel passing nearby. He spent one night at Valley Baptist Medical Center in Harlingen and was discharged the following afternoon. He was present at the sentencing. He sat in the second row of the gallery on the left side, and he sat alone. And when he gave his victim impact statement, he spoke for exactly 6 minutes and 40 seconds, which I know because I kept time quietly from the bench the way I always do. What he said in those 6 minutes was not what I expected. He said, "I don't want him destroyed. I want him to understand what those 4 minutes felt like from the water. If he can understand that, I think he becomes a different kind of person." That was what Darnell Furlow actually needed. Not the maximum, not retribution. He needed to be genuinely seen and understood by the person who had failed to see him. I have been on this bench for 19 years, and I do not hear that kind of clarity very often. I wrote it down. The charges were obstruction of a government vessel engaged in emergency operations and reckless endangerment under federal maritime statute. The potential sentencing range was 6 to 24 months of incarceration, a fine between $8,000 and $75,000, and a mandatory loss of any commercial maritime licensing, with optional community service provisions at the court's discretion. The federal prosecutor, Assistant U.S. Attorney Renee Castillo, argued for the upper middle range. She was not wrong to argue it. The facts supported the argument. A man had been in the water. A rescue boat had been blocked. Those are serious things, and they deserve to be treated as serious. Subscribe before I go further. Cases like this one do not happen as often as they should, and they deserve to be documented and heard the same way the harder ones do. Subscribe so you are here when I get to the part that made me remember why I chose this work. The procedural moment that mattered most to this case came during the pre-sentencing investigation phase, when the court-appointed evaluator submitted a psychosocial report. Under 18 U.S.C. Section 3553A, I am required to consider not only the nature and circumstances of the offense, but the history and characteristics of the defendant. That provision gave me something important. It gave me a door. Most people who watch sentencing hearings from the outside see a judge choosing a number. What they do not see is that I am required by law to look at the whole person, that this is not a favor I am extending, it is an obligation I am under. That is the tool I had in this case, and I was glad to have it. Because the psychosocial report on Marcus Okafor was not a simple document. It described a young man who had grown up in Beaumont, Texas, in a household where his grandmother, Paulette Okafor, had raised him and his two younger siblings after his mother's hospitalization when Marcus was 11. It described a person who had, in the year prior to the incident, donated approximately 20% of his platform income to a youth swim education program in underserved coastal communities, not publicized, not hashtagged, done through a direct bank transfer on the 15th of each month. It described one evaluator's observation, stated plainly and professionally, Mr. Okafor demonstrates consistent prosocial orientation that is not congruent with the choices made on July 14, 2023. That is a careful sentence. I read it several times. The morning of the first hearing, February 6, 2024, the gallery was about 2/3 full. Marcus Okafor's family occupied the right side of the back 2 rows. His grandmother Paulette was in the aisle seat of the second to last row. She was 71 years old, and she had a paper fan in her lap that she was not using, and she held it the way people hold something that gives them somewhere to put their hands. She was still for the entirety of the proceedings. That kind of stillness is its own kind of testimony. It tells you what a person is made of, that they can sit completely still in a room that is deciding the fate of someone they love. I noticed her the moment I sat down. I noticed the people who do not perform their presence. They are usually the ones who know what this room costs. Subscribe before I continue. I have been building to something in this story, and it is not where you might think it is going. Subscribe and let me get there. The first turn in this case came not during testimony, but during the playing of the video evidence. AUSA Castillo entered into the record the footage from the yacht's own camera system, not the brand reel, but the vessel's onboard navigation camera, which recorded continuously. We watched Marcus Okafor notice the Coast Guard vessel. The footage was clear. He looked directly at the boat. He saw it. He raised his hand toward his assistant, a gesture the assistant later described in testimony as meaning, hold. Then he returned to his shot. What I saw in that footage was not what I had expected. What I saw was not a person being callous about a stranger in the water. What I saw was a person who in that moment did not process what he was seeing as an emergency. He saw a government vessel. He did not, in the evidence as I could interpret it, understand that there was a man in the water waiting for that vessel. The emergency signaling at that distance, at that angle, with the audio conditions on the open water had not reached him. He failed. He failed completely. But the quality of the failure, that was what the footage told me, and what the footage required me to reconsider. This was not cruelty. This was the failure of a person who had learned to treat everything around his work as background noise. That failure had almost cost a man his life. I want to be very clear about that. It had almost cost a man his life. That was not going to be minimized in my courtroom, but understanding what kind of failure it was mattered enormously for what I was going to do about it. The second turn arrived with the testimony of Chief Petty Officer Alicia Mendenhall, the commanding officer of the rescue vessel, on July 14th. She had been called by the prosecution. She gave her account of the incident precisely and without embellishment, the way military witnesses do. Then AUSA Castillo asked her what she observed when 12 minutes after the rescue was completed, she returned to document the scene and encountered Marcus Okafor's vessel still at anchor. Chief Petty Officer Mendenhall paused. She said, "He was sitting on the bow. He had his phone. He wasn't filming. He was on a call. I noted in my report that his color was poor, and he appeared to be in some distress. He flagged me over. He asked me directly if the person in the water was alive. That was his first question, not about the charges or the legal situation, whether the person was alive." She said that. The prosecution's own witness said that. I watched the room absorb it. In the second row of the gallery, Darnell Furlow closed his eyes for 2 seconds. Just 2 seconds. Then he opened them and looked at his hands. I saw that, and I did not look away from it. That moment told me something about what resolution might actually look like, in this case, if I designed the sentence carefully enough. Subscribe. What I said from that bench was the hardest good thing I had done in a long time. Subscribe and hear it. The defense was led by attorney Carmen Yee of Houston. She was precise and she was prepared, and she did one thing I did not expect. In her closing argument, she did not argue that Marcus Okafor had not seen the Coast Guard vessel. She conceded it. She said, "He saw the boat. He did not understand what the boat meant." That is not an excuse, that is a fact. And the difference between those two things is exactly what the law under 3553A is designed to help this court navigate. That was an honest argument. Most attorneys in her position argue the facts differently than the evidence supports. She argued what the evidence actually showed, and she trusted the statute to do the rest. I respected that. I would have respected it less if the evidence had not supported her position. Marcus Okafor testified on his own behalf. He was not a polished witness. He stumbled twice and had to be redirected by his attorney once. What I remember most is not the stumbling. It is a single answer he gave to a question AUSA Castillo put to him on cross-examination. She asked him, "At any point before you anchored at that location, did you consider whether your positioning could affect vessel traffic in an emergency corridor?" He was quiet for a long time, long enough that I considered intervening. Then he said, "I thought I was out of the way. I've learned that thinking you're not in someone's way and actually not being in someone's way are two completely different things. I didn't know that yet. I wrote that down. Not because I needed to remember it, because I wanted to. When I was 23 years old, I was driving back from Corpus Christi on a night in late November, and I saw a car stopped on the shoulder of Highway 77 with its hazard lights on. I did not stop. I had a reason. I was late. The weather was marginal. I told myself someone else would stop. I have thought about that car many times in my life, usually when I'm sitting with a case that is about the distance between thinking you are not causing harm and actually not causing harm. I do not know what happened to the person in that car. I never went back to find out. I have carried that not as guilt exactly, more as a precise understanding of how easy it is to keep moving when stopping would cost something. I placed that memory next to this case, and it sat there quietly while I wrote the sentence. Subscribe. I have not told you the full sentence yet. I am about to. Subscribe before I do, because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. The room before I spoke was not silent in the dramatic way that courtrooms are sometimes described. It was attentive. There is a difference. Silence is an absence. Attention is a presence, a specific pressure in the air that comes from people who want something particular to happen and do not yet know if it will. Marcus Okafor was sitting with both hands flat on the defense table. His grandmother was sitting in the same position she had occupied all morning. Darnell Furlow was very still. I had made this decision carefully. I had made it knowing that mercy, to mean anything, has to be precise. Vague mercy is just hope. Precise mercy is a plan. I had a plan. I said the following from that bench. I am ordering you to pay restitution in the amount of $12,400 to Darnell Furlow, directed specifically to his medical expenses, lost wages during recovery, and the cost of the paddleboard equipment lost in the incident. That is not a fine. That is not a number I chose abstractly. That is the number that makes Mr. Furlow whole in the measurable sense. The law can only do the measurable part. You are responsible for understanding that the unmeasurable part exists and that no ruling can reach it. I am also ordering 40 hours of mandatory instruction, not a general boating safety course, but a certified maritime emergency protocol course conducted with and certified by an active Coast Guard station. You will complete it within 90 days of today. The reason is specific. You did not understand what that rescue vessel meant when you saw it. You will understand it after this. That is not punishment. That is the court requiring you to become less dangerous. Those are different things, and I'm asking you to understand the difference. I am ordering you to produce, publish, and personally present to the manufacturer whose brand you were contracted with on July 14th a full accounting of what occurred during that filming, unedited, unsponsored, without commercial attachment of any kind, and to make that accounting publicly available through your platform, not as a PR gesture, as an act of transparency that restores something to the record that your work that day obscured. The outdoor industry, which you have profited from, has a culture of safety on open water. You will contribute to that culture in a lasting and traceable way. I'm ordering 120 hours of community service with the South Texas Search and Rescue Volunteer Organization. You will report directly to the unit coordinator. You will do whatever they ask of you that is within your physical capability. You will do it without your camera. If they choose to document it, that is their decision. This requirement exists because you have skills, organizational skills, an audience, a capacity to direct attention, and those skills belong in service of the kind of people who spent 14 minutes on the water waiting while you were thinking about your shot. And I am ordering no period of incarceration, because the evidence in this case does not support incarceration as the tool most likely to produce the outcome that serves Mr. Furlow, serves the public, and serves the purpose of this court. I arrived at this decision under the full provisions of 3553A. I stand behind it. There is one benchmark you can meet. If, within 12 months, you have completed all 4 requirements fully and can demonstrate through documentation that the community service hours have been verified by the unit coordinator, you may petition this court for a reduction of the restitution payment by 15%. That is the court's way of saying something I want to state plainly rather than obliquely. I believe you are capable of doing everything I have just described. I believe it because of what the evidence showed me, not because of what you told me. Evidence is what I work with. The evidence points toward you. Do not waste that. Then I said this directly to Marcus Okafor. I said, what you did on July 14th nearly cost a man his life. I want that sentence to land, and I want it to stay. Darnell Furlow was in the water. He was cold. He was afraid. He was waiting for help that should have arrived 4 minutes earlier than it did because you were in the way, and you did not know you were in the way. That is the thing you are going to live with. No sentence I give you reaches it. What I can do, what this court can do, is give you a structure that requires you to spend the next year becoming someone who understands what you did not understand that day. I looked at everything in this file. I looked at the donations that nobody posted about. I looked at the letter your grandmother drove 4 hours to put on my desk. I looked at the footage. I looked at you. I believe you are capable of being useful to people who need the things you are capable of giving. That is a specific belief, not a general one. Earn it. Thank you for staying with this story. It is not the kind of story people usually tell about courtrooms. Subscribe if it is the kind of story you want more of. I have more to tell. When I finished speaking, I sat still on the bench while the room gathered itself. Carmen Yee put her hand briefly on Marcus Okafor's forearm. Not a gesture of celebration, a gesture of arrival. He nodded once. He did not look around the room. He looked at Darnell Furlow, who was still seated in the second row. Darnell Furlow looked back at him. They held that look for perhaps 3 seconds. I did not look away. I am glad I did not look away. Then Darnell Furlow gave one slow nod and stood up and walked out of the room ahead of everyone else with the careful walk of a man who has decided something for himself. I picked up my pen. I set it back down. That felt like enough for a day. On March 3, 2025, I was informed by the South Texas Search and Rescue Volunteer Organization's unit coordinator, in a written certification submitted for the court record, that Marcus Renfield Okafor had completed his 120 hours. He had been present for 3 open water trainings. He had, on one occasion, assisted in locating a kayaker who had drifted off course in Laguna Madre. He had not brought a camera. No appeal was filed. I noted that when the deadline passed, it told me something, not about guilt or innocence, but about a person who had decided to accept what the court designed for them and try to work within it rather than around it. I found that quieter than a verdict. What I have come to believe through this case specifically is that precision and compassion are not opposite ends of a spectrum. They are the same tool used well. It would have been easier to sentence Marcus Okafor to incarceration. Easier for me from a procedural standpoint, easier to explain. A person was almost killed. A responsible party was before the court. A straightforward application of the range's upper end would have been defensible. But defensible is not the same as right, and I have been doing this long enough to know the difference in my body before I know it in my reasoning. What this case gave back to me, not as a judge, but as a person, was the reminder that designing something carefully is harder than applying something bluntly, and that harder is usually where the right answer lives. To anyone who has been where Marcus Okafor was, who caused real harm and is now carrying the question of whether there is a road forward that is not just waiting for punishment to end. What I look for from the bench is not remorse that is performed. It is one specific thing. Whether the person in front of me has thought more about what their actions cost someone else than about what the charges are going to cost them. You can see that distinction. It shows in where a person's eyes go when they're not sure they're being watched. If that describes you, if you have genuinely spent more time thinking about the harm than about the sentence, then there is something you can do with that. You can bring it into the room with you, not to persuade me, to be ready for whatever the room asks of you. That is the door. To anyone who has been where Darnell Furlow was, who was asked in the aftermath of being harmed, to consider what mercy for the person who harmed you might look like and who did not know whether that was the right thing to want. I cannot tell you what to want. What I can tell you is what I have watched happen to victims who chose something like what Darnell Furlow chose. From where I sit over many years, what it seems to do is give them back the part of the story that belongs to them. It does not erase what happened. It adds something, a sense of having participated in what came next rather than only having experienced what came before. That is not a prescription. That is a witness account offered plainly from 19 years on this bench. Subscribe. I am about to tell you what happened after the sentence, whether this person did what I believe they would do. Subscribe so you are here for that part. It is the part I care about most. There is a man somewhere in South Texas right now who on March 3, 2025, completed 120 hours of work with people who spend their time pulling strangers out of water. He did not bring a camera. He helped find someone who was lost. That is one specific day, one specific thing, one person doing something he might not have done if a courtroom had made a different choice. I am not going to tell you whether it was enough. I am going to tell you it happened. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I am asking. Subscribe and stay. And if you have something to say about what you just heard, leave it below. This is a room for people who understand that justice and humanity are not in competition. That is the conversation I want to be part of.